The question sometimes comes up when someone inherits a home, that their relative is living in the home, and they ask, well, what do I do to get these people out of the home so that I can sell it? And the answer depends sometimes on whether those people were acting as a caretaker for the decedent, and their tenancy is dependent upon them serving as a caretaker, or whether they were simply just living there as the daughter of the decedent. But generally, you're going to have to give them a notice terminating a tenancy. If they were what would be considered a tenant at will, in other words, they weren't paying any rent, there was no rental agreement, they're still entitled to a 30-day notice of termination of tenancy. From a real estate standpoint, there could be other manners of removing a tenant from the property in situations that might normally require, say, a 60-day notice. If the property is in escrow, with an escrow is opened, and it's a good faith purchase, and the property is separately alienable, in other words, it's not a multi-unit building, then only a 30-day notice need be given, despite the fact that normally the tenant would be required to be given a 60-day notice. The owner could get by with a 30-day notice in those limited circumstances. Longer tenancies, if it's an actual rental situation, sometimes, in other words, the child is paying rent to the parents. If it were a rental situation, if they were living there less than a year, they would still get a 30-day notice. If they were living there longer than a year, they would need to get a 60-day notice of termination of tenancy in writing, which is a specific form. It's not simply a letter saying you have 60 days to get out. After the 30 or 60 days has expired, a complaint for what's called unlawful detainer, which is another word for eviction, gets filed if the sister is still living in the property and has not vacated. The complaint for unlawful detainer is filed, a summons is filed with it. The summons and the complaint are then served on the tenant, and they have 5 days to file a written response to that summons and complaint. If they do not file a written response within the 5 days the law permits, then their default can be taken with a form. Usually an attorney does this, but there's nothing that says you can't do it yourself if you knew how to do it. Their default is taken, a default judgment is entered, a writ is applied for to the court, and the writ is issued. The writ is taken to the sheriff with a set of instructions to the sheriff, and the sheriff then serves on the tenant and posts on the property a notice to vacate. That gives the occupant 5 more days to get out. The sheriff then returns with the owner or the owner's representative and removes anyone still on the property and relinquishes possession back over to the owner.